Okay, thank you. Okay, so it's the date and time of sentencing. Mr. Leady's here with Mr. Conley by Zoom. The conviction here is...
Your Honor, may I make a statement first? We've never agreed through the country to approve Zoom court hearings. Those are unconstitutional. Okay. I don't know if I'm on it or not. You tell me. I have no idea. I never used any of this shit. Yeah.
Sir, over there. Hey, over there in room D, don't use profanity.
Nothing.
So the original charge was impersonating a public officer, which I think is a 1-year misdemeanor. It was reduced to drunk and disorderly in 90-day. The case was intended to be referred to probation for a pre-sentence report. At the time of the plea, which is October 9, I indicated to Mr. Hooker he needed a
patient, and then transitioned into the tea house where he started to do the meetings and things of that nature. So that's where he has been during the pendency of this case. He was on bond on this case, I believe 8 times monthly testing, and he's being...
Okay, so then in this case, there haven't been any bond violations?
Not that we've been alerted to.
Disposition of, I guess, the arraignment, where the magistrate would have said, you know, other healthy people that are in recovery that can support you and... Okay, all right. So when
he saw the discovery material, and it was an eye-opener. He and I discussed it, seeing the drunkenness, seeing the way he was acting. I do think got him, you know, an eye-opener that, hey, I got a problem. This is not who I want to be. And it sounds like, you know, that stay in Dikoski did make some good changes and got him in the right direction. And that's evident by the way he's performed in his testing while on bond. He is under supervision, as we've already discussed. So I do think the fines and costs at this point, with credit for time served.
Some other things that made absolutely no sense, and I don't even remember doing it. My PO showing me the video was it was a shocker. I didn't even know I was being videotaped though. So
okay, now I remember the facts of the case.
All right, I have to thank Brecken for this. I was sold this as a sovereign citizen. I don't see anything sov-cit yet, but it doesn't matter. He's fantastic. And then the other one that's on the thumbnail is great. That was sent to me by Brecken and also Alyssa. That one's great as well. Let's keep going.
Now that you mentioned walking out of the woods, and I misspoke. It's impersonating a public officer. So, all right. I don't see the need for probation. I think Mr. Hooker is doing what he needs to do to address the issues, and he is on supervision.
Result of losing his job. How many years had he worked for?
I'd been with the public schools for 7 years.
So I think at 10 he would have vested for his pension.
I would have vested for my full pension, because I worked many years ago when I was in college. I'd worked at NMC as a janitor and a lawn and garden maintenance. So I was entitled to the original pension, which was a defined pension when I had my 10 years in. But part of the agreement with the public school system was when I resigned that I'd lose all my rights to that.
Okay.
I can't work in the public schools or even drive a bus.
Walking the microphone, there's a video of it. And so my client swats him on the butt and sends him back where he came from, but you just can't swat kids these days, Judge. That's what it is. So, I mean, I think his temper probably got the better of him, and he had enough of the monkeying around, for lack of a better term, up there with the front of the bus. And he, instead of stopping the bus and sending him.
There was no intent to injure the child. I just kind of swatted his behind like that, to kind of like, get going, get out of the way.
What level her drinking problem had gotten to, but nobody got hurt here, Judge, and it's given her an opportunity to seek out some help. So attached here, I believe Your Honor's got a copy of her health clinic mat treatment.
No. Wait. Yes, I'm sorry, I do.
Okay. Yeah. So there's the letter there, indicating she's engaging in treatment.
It's a dangerous situation. Do you understand that? All right, but based on everything else, including the assessment, which was pointed out by Mr. Conley, took this to realize he had a severe alcohol use disorder. So probation and its terms are appropriate. I don't know what this gentleman is doing from room D.
It's Mr. Leady, Your Honor.
Oh,
He's been doing it now for the last half hour, so I don't know.
yeah, I know.
That's why I'll do that on Zoom, Judge, so I can break it off and see what's.
Okay, that sounds good. All right, so probation will be 365 days as recommended. And actually, ma'am, at the halfway point, $275 attorney fee, arrest fee of $125, blood fee of $22.30. While on probation, may not consume or possess alcohol, illegal drugs, or mood altering. We closed the breakout room.
Take it off.
I sent a message to room C there at the jail for Mr. Leady to unmute.
Are we unmuted?
We're unmuted. Yeah.
Oh, okay, good.
Oh, yeah. So I guess we'll have to let it time out like we did before.
Probably, yes.
So, Mr. Leady, you're unmuted. Can you hear me, Mr. Leady?
Yes, I can.
Okay, thank you. Okay, so it's the date and time of sentencing. Mr. Leady's here with Mr. Conley by Zoom. The conviction here is?
Your Honor, may I make a statement first? We've never agreed through the country to approve Zoom court hearings. Those are unconstitutional. We
Okay,
have the
hang
right
on.
to see our accusers eye to eye.
Okay, hang on. You can speak, but let me just confirm with Mr. Conley that the report is actually accurate. Is that correct, Mr. Conley? And you're muted, Mr. Conley?
I'm sorry, Your Honor. Your Honor, it's kind of impossible to verify that with Mr. Leady at this point because he doesn't really want to discuss the case. So I'm not sure what to do, Judge.
Well, I can show you, Your Honor. I was never read my Miranda rights. I never had the ability to talk to Ali Khan or Conley.
Yeah, and,
These
Your
are
Honor,
the problems.
and I've talked to Mr. Leady multiple times, Your Honor, and we went over this at his plea. And again, he asked me who I was, that he's never talked to me, that, you know, I just don't know what to do at this point, Judge. So.
Yeah. Well, so.
And I explained the as well, Judge. So.
Well, the contents of the pre-sentence report, I guess, are consistent, I guess, with the way Mr. Leady is handling today's matter and what he said so far and how he's handled the breakout room conversation or competency at all, Mr. Conley?
Absolutely. At this point, I would say absolutely, Judge, because I don't know how to know what the best way to put it is, to keep him on track. Like, he doesn't focus on what we're here for today. And he's got a lot of other things he's upset about, and they don't relate, in my opinion, to what we're here for today, but he thinks they do. And I don't know, Your Honor. I think he feels that myself and the court system are against him, which isn't the case. And I think that's a problem. So it's hard to have any productive communication with him when he is in this kind of state of mind. So.
Now pay very close attention. This is the moment that separates someone making unusual legal arguments from someone the court may believe is legally incompetent to proceed. Listen to what the defense attorney says next. Isn't the prosecutor questioning his client? It's his own lawyer expressing concern that meaningful communication has broken down.
Okay, so the charge is a serious charge, malicious use of a telephone. You put no contest, I think. Is that a 1 year or a 6 month, Mr.?
The original charge is a 1 year, Your Honor. So telecommunications malicious use is up to 1 year in jail.
All right. I mean, the information taken from the police report is very serious. He called, called Beta, and then he contacted I thought it was the VA after reviewing this last week, but I don't think so. He called back. Or no, the person who reported this called him because his number showed up from the original call, I'm guessing, and he said he was a real vet and he was going to take their system down. That's a quote from him. There was a mental health mental health order in lien. Not sure when that was. Anyway, these are just circumstances where I think he's a danger to the public. Maybe he should be on probation. Maybe he should just get the full year in jail. I don't know. But if there's a question about competency, and based on his behavior here today, I believe there, and based on what he told his probation agent, including he's talking about texting being an unconstitutional event, notarizing to being unconstitutional, claims that I guess this case or his discussions with probation will be heard around the world. Again, this is a quote from him. He stands up for people who don't have the ability to stand up for themselves, which is good, but I don't know about the heard around the world part. Anyway, I don't think he should be sentenced without the benefit of a competency report. I just don't. The question is, though, those things usually take a long time. Do you know, Mr. Conley, if that can be expedited at all? Because he's in jail.
I have them, once they actually make the appointment by video in the jail, within a week or two, it seems like they've got the reports done. So I think they probably can expedite that, but I don't want to speak for them, Judge. But they have been generally quicker for those that are in the jail than people who are not.
Okay, well, that's good. That's better than it used to be a year or so ago. The other thing, though, is we don't have a prosecutor here, and we should for this. Prosecutor does the orders for competency. So what I think we should do, can we adjourn this for like a day or two when that fits with Mr. Conley's schedule so we can get the prosecutor here? Because they need to know that this is what I'm deciding, and they need to know they need to do an order. And
I can tell them, Judge, if you want. They'll do it if I call over there and tell them.
I could put it on the disposition as well.
Yeah,
Okay.
They'll do it, Judge. As long as either yourself or I ask it for it, they'll do it.
This is another critical moment. The judge isn't deciding guilt here. He's reviewing the allegations alongside the defendant's courtroom behavior. Allegations like threatening voicemails don't prove someone committed the crime, but they can become highly relevant when the court is deciding whether a competency evaluation is necessary before sentencing.
Well, that's true. The statute basically says once it's just the word is stated, then we have to slow things down and get the report done. So, all right, that's what we'll do. I'm going to continue the remand at this time. I think, though, we should set this for like a status conference in 30 days because Mr. Leady's been in jail for 76, and just a status conference to see if anyone's heard from forensics. Okay, and what we'll do is we'll send out a notice for that then, Mr. Conley. Okay. Mr. Conley, you might be frozen.
Yes, Your Honor.
You're frozen. All right.
Thank you, Your Honor.
You heard? Okay, so you're all set here.
No, I think
Mr. Leady?
I think I heard. Yeah.
So we're going to set this for a hearing in 30 days, which will just be a status report just to see whether anyone's heard from the forensic department, okay? And I don't know if you heard that, Mr. Conley.
I did, Judge. I heard it. Thank you.
Oh, okay, all right. So that's what we'll do. Mr. Leady, you're all set. You can let the COs know you can go back, okay?
And Your Honor, I have one more sentencing for Ms. Lewis
Ms. Lewis.
in the jail.